Welcome to another episode of TrialSite News. Today on our show, we're going to be discussing a medical freedom victory. A 22-year Naval enlisted lieutenant opted out of COVID-19 vaccine and wins in a Naval board hearing. We're going to discuss what happened here. And so, from TrialSite News, I am Adrian, and our episode is starting right now. So, a scientist and expert witness shared with us here at TrialSite News a recent legal case involving a 22-year Naval enlisted lieutenant. The winning law firm, Davis Younts Esquire, reported that on May 20th, 2022, a board composed of 3 Navy officers found that the firm's client, Lieutenant Bill Moseley, did not commit misconduct by refusing a COVID-19 injection and found unanimously that Lieutenant Moseley should be retained in the United States Navy. And so it seems a victory for medical freedom. Attorney Younts represented Lieutenant Moseley at the administrative hearing and successfully argued that the order for military members to receive the experimental COVID-19 injection was not a lawful order. In particular, Attorney Younts successfully demonstrated that the military has not made the FDA-approved version of the vaccine available to military members. So what does this mean exactly? Well, we here at TrialSite News reported that when the Pfizer-BioNTech vaccine was apparently approved, it was actually an unorthodox move that included 2 things. First, you had an approval of the Comirnaty vaccine. And then at the same time, you had a continuous embrace of the BNT162b2 vaccine as an investigational product under the Emergency Use Authorization, otherwise known as the EUA. Now, at the time of the FDA decision, there was no Comirnaty product in production, meaning the only product in circulation in the United States was still the BNT162b2 vaccine, but no Comirnaty. Now, at the time, we here at TrialSite News suggested that this decision, possibly influenced by the Biden administration, was a strategic move to legitimize numerous pending mandates at the federal and local levels. So, to illustrate this, let's use the Wayback Machine and go back to August 31st of 2021, and here's what we wrote at TrialSite News in an article about this story. With the recent Food and Drug Administration approval of the mRNA-based vaccine Comirnaty came the assumption that the liability shield protecting the drug and vaccine manufacturers, in this case Pfizer, would be lifted as the emergency use authorization, as the EUA would be no longer needed. But this isn't the case at all with this most recent authorization under the Biden administration. No, the reality is very different today for the healthcare consumer. Of course, one frequently discussed policy driver for the FDA approval of Pfizer's mRNA-based vaccine was to reduce vaccine hesitancy. That is because the general public would perceive the vaccine to be permanently approved instead of an emergency use scenario. However, not widely broadcast to the public is the support the approval provides to back up widespread vaccine mandates at the federal, state, and local employer level to the private sector. The recent approval was unorthodox because it involves 2 distinct letters, one to Pfizer continuing the emergency use authorization, and the other to BioNTech granting full approval to Comirnaty. Most healthcare consumers don't realize that the recent FDA approval does nothing to protect their interests should injury or death result from inoculation. That is because both the approval and the emergency use authorization fall under what is called the Public Readiness and Emergency Responsiveness Act, also known as the PrEP Act. Now, those pharmaceutical companies that have approved products, such as Pfizer, are benefiting on both sides, while they maximize revenue thanks to mandates and minimize legal risks thanks to all-encompassing liability shields under the PrEP Act. Moreover, we here at TrialSite News are suggesting that the duration of this coverage could run up until 2024. So, now let's go back here to the present in 2022. To comment on all of this, TrialSite News founder Daniel O'Connor said on this matter that, in fact, right after this unorthodox move, numerous mandates were introduced. The approval provided the legal basis for the mandates. Many Americans assumed that once approved, Pfizer then would have liability for the vaccine. But this was by no means the case, as among other protections, the enacted PrEP Act ensured blanket liability protection against any litigation except for the extremely difficult to prove edge cases of criminal activity. So back to Lieutenant Moseley, who opposed the vaccine for religious reasons and could have submitted a religious accommodation request. However, when he learned that the Navy and other services intended to implement a blanket denial policy, he began to consider other options. After consulting with legal and medical experts, he became convinced that as an officer, he had an obligation to take a stand against what he considered an unlawful order and be a voice for thousands of enlisted sailors. Consequently, Lieutenant Moseley risked his 22-year career and his military retirement because of his determination, led by faith, political commitment to a principle of medical freedom, and his commitment to his oath of office as a military leader. Although this is only one case out of thousands, this law firm has many more clients facing prosecution by the military. The firm's principal, Davis Younts, is encouraged by the decision and hopes that this groundbreaking case sends a strong message to the Department of Defense. Now, it is also worth noting that Lieutenant Moseley's legal defense was supported by a Medical Freedom Fund grant from the Truth for Health Foundation, a 501c3 public charity committed to defending medical and religious freedom guaranteed under the U.S. Constitution and secured by law, as a result of the generosity of donors supporting the foundation. You can find out more about them at truthforhealth.org. Now, if you're also interested in finding out more about the attorney, he can be reached at 833-739-5291 or davis@younslaw.com. And that, my friends, is bringing our episode to a close once more. As always, thank you so much for joining me on the program today. From TrialSite News, I am Adrian, and I will see you all next time.